pray that it may be taken up on second half, madam. Admission.
After vacation. Item number 9, the request of the learned counsel for the appellant to be listed after vacation.
Item number 7, can we be posted after vacation? Can it be taken up after vacation?
Item number 7, the request of the appellant, matters stands adjourned to be listed after vacation.
Tomorrow the FAO interlocutory application is there. Can I move it tomorrow, man?
No, not before me mentioning.
The FAO is as per roster has been allotted to this group, man.
FAO is also with justice here. FAO is there,
Put number
Good.
12.
where is the senior bench?
Please, Your Lordship, in item 19, we have filed our affidavit in opposition. In item 19, we have filed our affidavit in opposition. Kindly the record may be called for.
Please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item number 20. Lordship, my senior is out of station due to passing away of his younger sister. The matter may be taken up after the vacation.
Does this have anything to do with this protect? Protect that company?
I'm not in this. Protect.
Yes,
Item number 20.
20.
That's the protect? Manoj Jalan? Not before me. Item number 20. huh?
I have to mention one I in MSC appeal, which may listed on tomorrow.
Go to court number, the other court, Justice Pukan's court. Go mention there. No mentioning business.
It's not there. Court number 12 is on there.
Not sitting today. Is there any notice issued that I should take it up? Can't help it.
Yeah, I was also praying for a listing now. Injunction. will
I
be-
can't give you. Unless I have been given the authority, I have no authority.
To pray for listing when awaiting the order for it. And present.
Court number 12 is not sitting, Bala.
I can't help you. I have not been authorized.
But no other bench is there, Mala, for
Go mention it before the Chief Justice acting. That there is no bench sitting, how do I take it? He will take care of it. It is his business, not mine. I sit only when my roster is being given to me. Yes, what is this?
Mallet, this petition has been filed Mallet, agreed to it and order passed by the Railway Tribunal Mallet. Regarding Mallet, for that petition has been made for release. A fixed deposit.
Oh, that one.
As per last order Mallet, I have filed an affidavit Mallet. Mallet, from the last page Mallet, the situation name within Mallet.
You want the entire amount?
Yes, LRC. Yes, LRC.
Husband, wife, both,
Both Mallet.
both the amounts. Let them take what to do. They don't want it for themselves. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Ms. Agayan appears on behalf of the respondents. First, the instant petition has been filed challenging the order dated
8/4/25. H is 41 for that.
8/4/2025, passed by the member Judicial Railway Claims Tribunal, Guwahati Bench, whereby the application so filed being misapplication number MAGHY/012/2025 was dismissed. Full stop. It is relevant to take note of that the Railway Claims Tribunal Guwahati Bench had in OA Roman 2 small u there 17/2023 by the judgment dated 29/2/2024 awarded an amount of rupees 8 lakhs with 6% interest from the date of the accident to the date of the order, and further directed that if the said amount is not paid within 90 days, the amount shall carry interest at the rate of 9% from the 91st day of receipt of the order till actual depositing. Full stop. It was also mentioned in the said order that a compensation which is to be paid would be distributed in equal proportion between the petitioners. Full stop. The learned tribunal further observed that the said amount of that out of the said amount, 3 lakhs each shall be kept in the fixed deposit in a nationalized bank for 3 years. And on completion of 3 years, the entire amount of interest amount along with interest will be transferred to their respective banks to their savings bank account. Full stop. It is relevant to take note of that pursuant to the said directions, the amounts were duly deposited, and the applicants herein have received an amount of rupees 2,83,000. Full stop. However, on account of the urgent necessity, the applicants filed an application before the learned tribunal, which was registered and numbered as MAGHY/012/2025 for release of the remaining amount which have been kept in the fixed deposit. The said application was rejected, and it is under such circumstances the present application has been filed. Full stop. This court have duly taken note of the additional affidavit which have been filed in pursuant to the order passed by this court. And from the said additional affidavit, it appears that the petitioners who are the applicants who are presently 62 and 65 and 62 years respectively, 65 and 60 years respectively, are in urgent need of the said amount. Full stop. Under such circumstances, it is therefore the opinion of this court that the learned tribunal ought to have taken into consideration the said application and allowed it. Full stop. Accordingly, this court allows the relief so sought for in misapplication number MAGHY/012/2025 and further directs the learned tribunal to pass appropriate orders upon a certified copy of this order being produced before the learned tribunal. With the above, the instant petition stands disposed.
But in this case, my lord, our written statement is otherwise ready, my lord. Your lordship, on the other day, my lord, asked my lord whether the WS is ready, my lord. Yes, my lord, now WS is ready. We can file it by 27/6, my lord. Here, my lord, single date, your lordship will find we have sought for adjournment, my lord, single date. My lord, that has been turned down by the learned trial court, my lord, at page 62, the impugn order. Sir.
Issue notice making it returnable on 4th of August 2025. Steps be taken upon the respondent numbers 1, 2, and 3 by way of registered as well as usual. In addition to that, the petitioner is further directed to effect service upon the respondents by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Pustak. The petitioner herein has approached this court challenging the order dated 25/2/2025, whereby the petitioner have been in title suit number 122/2024, whereby the learned court of the civil judge senior division Kamrup at Amingaon has rejected the application, rejected the petition seeking extension for filing of the written statement. Gustav, it is seen that the learned trial court have rejected the said application on the ground that the 90 days period is over pursuant to receipt of the summons. Gustav, the learned counsel, Mr. B.K. Sen, the learned counsel appearing on behalf of the petitioner submits that the written statement is ready and can be filed on any day as may be directed by this court. So taking into account the overall materials on record, this court is of the opinion that till the next date of the further proceedings of title suit number 122/2024 is required to be stayed. Accordingly, further proceedings of title suit number 122/2024 pending before the court of the civil judge senior division Kamrup at Amingaon shall remain stayed till the next date.
Highly obliged. Highly.
Made previous lordship, my lord. My lord, on limited ground, my lord, I am approaching this honorable court, my lord. That
What is wrong with these people?
yes, my lord.
This is a huge cost would be imposed upon you now. How many times do I have to pass orders?
Yes,
Last 6 months I've been taking bench one. This is the third petition I find out. What is wrong?
my lord, now, my lord,
These people should be.
appeal is pending, my lord. At
Wha-
this stage,
what
my lord,
appeal?
earlier, my lord, at this stage, the suit was
What
pending.
appeal? There is
My
no
lord,
appeal
title
business.
appeal is pending, yes, in against the first order, my lord, no appeal pending, second appeal also disposed of, my lord. And my lord, that initial suit, my lord, decree challenge in the subsequent title suit, my lord. And that against the judgment, our appeal is pending on the limited ground, my lord, page
No appeal
169.
business. No
Order-
appeal business. How many times do I have to pass orders?
My lord, that's correct. My lord, order 21, rule 26, my lord. Because
Nothing.
appeal court cannot stay the other decree was earlier suit. My lord, we have taken the ground in the appeal that eviction is not advised under the my lord, Plantation Act, my lord. Only 10% enhancement can be imposed. My lord, 66(2) Assam Plantation Labor Rules 1956. My lord, so defendants cannot seek for eviction from the quarter. Only, my lord, the Tiga company, my lord, they can claim 10% of the wage, last wage. So eviction is barred under this, my lord. So on that ground, this appeal is pending. And
Now,
moreover,
this time I am imposing a cost.
my lord,
I am imposing a cost upon the council of 50,000. Upon the council. This is an absolute Every time there is counsel after counsel coming out before this court, how many times it has to be dismissed?
20.
Nothing doing. After this order on 29/4, there is nothing doing,
My lord.
nothing doing.
And- My lord.
No ground. I'm not going to hear any grounds. After eviction is completed, then only. I'll only, no, I'll do one thing. You know what to do. I also know how it is to be done. Issue notice. I'll take care of you, how it happens now. Issue notice, making it returnable on 4th of August 2025. So steps be taken upon the respondents by way of registered as well as usual. Now issue notice, making it returnable on 4th of August 2025. Steps be taken by way of registered as well as usual. Full stop. The petitioner has approached this court challenging an order dated 9/6/2025, whereby
Uh,
whereby
Case
The-
178 is the relevant portion. my lord.
whereby the application filed under Order 21, Rule 26 was rejected. Rejected, na?
Yes.
Rejected by the learned executing court, being the court of the civil judge, Junior Division, Naharkatia, in title execution case number 5/2019. Full stop. This court have duly taken note of that the petitioners herein have adopted all means by which the execution of the judgment and decree passed in title suit number 223/1975 can be thwarted. Full stop. Full stop. Taking into account the materials on record, this court is not inclined to stay the further proceedings of the execution case. Full stop. On the other hand, this court directs the learned trial court, the executing court, to proceed with the execution and submit a report before this court on the next date, full stop, as to whether the execution has already been carried out.
My lord, may be allowed to withdraw this.
Withdraw. The learned counsel appearing on behalf of the petitioner submits.
Stay is not there that the purpose.
Stay, no, I am not only granting a stay, I am directing them to comply. But I am imposing a cost upon you. No, I'm imposing a cost. Mr. Who's the Lehok ekhini? I'm imposing a cost upon you. No, cost is different. I'm not on the petitioner now. The cost is upon you. Because you are withdrawing after the passing of the order. So I'm imposing a cost upon you, 50,000. And this happened. No, nothing doing. Mr. Das, don't take up a matter just for the sake of it. 1975,
Yes, I understand.
2011, the matter finished out here in the High Court. And for the last 14 years, he has not been able to do it. I, by myself, have passed 4 orders.
Right.
And these
supposed-
orders have been passed every time another council comes up with all these things. So therefore, now you are to be blamed, you pay this 50,000. Nothing doing. This 50,000, I'm imposing a cost on withdrawal. You cannot withdraw. I'm not withdrawing it. Let it remain, let the directions go for compliance and the registry is directed to proceed, send a copy of this order forthwith to the learned executing court.
From the last occasion, your lordship directed to file a additional affidavit in regarding the bona fide requirement. So I filed that on 18/6.
You filed it?
Yes, yes.
You want to reply?
I'm under. Yes, ma'am.
Mr. A, well, the learned counsel submits that he may be given an opportunity to withdraw a reply to the additional affidavit filed by the petitioner. Who's list the matter again on 13th of August 2025. In the meantime, the affidavit in opposition be filed.
Deeply obliged.
With the lordship. Lordship, here the petitioners are the defendants of the commercial suit. And when the matter was posted for filing of the written statement, then on that very day, a single default was occasioned on my part. And as a result, my lord, the court proceeded expert. And on that particular day, 120 days was not found. Thereafter, the very next day, the defendants filed an application under Order 9, Rule 7. along
Mr.
with that-
Chopra, what do you say here?
My lord, kindly say page, paragraph number 4 of their petition, para 4. I'm reading that. The petitioner beg to state that herein, this case, if we calculate the mandatory 120 days from the date of submission of documents before the court, that is from 35/24, the period of 120 days would expire on 27/9/24. On the other hand, if we calculate the period of 120 days from the date of actually receiving the documents, that is from 15/7/24, the period of 120 days would expire on 12/11/2024. But his submission is that due to wrong posting, he could not appear on the fixed date in September. Anyway, but he's admitting that he received the documents on 15/7/24. If you calculate from that date also, even if he has misquoted the date in his diary, then also he ought to have filed the written statement with the 120 days from 15/7/24. On an off date also, there is no bar. When he has admitted that he received the document 15/7/24. Even if the date is fixed after or prior to 120, then also he is mandatorily required to file the WS within 120 from that date. And now, my brother is saying that he filed the petition on the next date. No, my lord. On which date he came to know, that he has not mentioned. I'm reading the next para number 6. The petitioner begged to state that on 19/9/24, the defendant failed to appear before the trial court, as well failed to submit their WS, as the counsel for the defendant wrongly posted the date on 25/9/24 instead of 19/9/24 on his advocate's diary. As a result, when by order dated 19/9/24, the Court of London Civil Judge, Senior number 3, Kamrup, Guwahati, was pleased to proceed ex parte against the defendant, fix the matter on 29/11/24 for ex parte evidence. It is pertinent to mention that London trial court ought not to have passed the order of proceeding ex parte, but ordered in 19/9/24 as the period of 120 days from the date of submission of
This
documents
is
before the court
okay.
would expire. My
This
lord,
is another thing, but the fact remains that on 19/9/2024 was the date fixed.
yes, my lord,
On the date, he could not appear,
my lord.
and the court fixed the matter on 29/11/2024 for ex parte evidence.
My lord.
Now, how do you take care of Order 9, Rule 7?
My lord, I'm not objecting on that for provision there, but even if the date was fixed on before 120 or whatever, on the date fixed, he was not present. So normal procedure that if the defendant does not appear, the court proceeds pass order for ex parte proceeding. Now, even if he could have filed the WS within 120 days, he could have filed a petition for vacating ex parte order. But that he does not do.
Understood, but as on that day,
My lord,
when it completes the 120 days,
my lord.
that is on 12/11,
Yes,
or,
my lord.
or the other date is on, actual date should have been
Uh,
27/9.
Yes.
27/9. On 27/9, when it is completed, he could not have filed the WS? Could he have filed the WS?
He could have filed the WS, but he
How?
is saying that he received the document on 15/7.
No, let us assume that he
Anyway,
received on
He,
5/7.
from both counts, my lord, the WS is not filed within time.
Understood, but could he have filed the WS?
My lord,
Could he have filed the WS?
he could have filed the WS within 20 days,
How?
20 days, not after that.
How? because the suit is proceeding ex parte against him unless.
On nine, that
So
is
it-
filed on 19/9/24. Even my lord, the date on which he filed the WS, on that date also the order was for ex parte proceeding. But he filed the WS along with the copy for, along with the application for vacated ex parte order. He could have filed that petition along with that copy of WS, along with the WS prior to that also. When he can file the petition for vacated ex parte order on the date fixed.
No, understood. But the moment you allow the application under order 9 rule 7 means you show a good cause.
No good cause is shown.
Understood. It's a different thing, no good. If there is a good cause, what is the effect?
Even then, this should have been within 120 days, my lord, as per my submission, my lord.
Now, if you show good cause, then
If a good cause is shown, then the court can vacate the ex parte. But
no, it's not a question of vacating ex parte. You can very well participate in a suit
that he has
at
been
any
allowed.
point of time.
He has been allowed.
No, whether it is allowed or not, he can very well participate. There is no quarrel with that proposition. The law is settled from 1955 onwards. But the moment he shows good cause, the suit goes to the stage on the date on which it was proceeded ex parte.
My lord, yes.
Okay. Now, as on the date on which it has proceeded ex parte, if the good cause is shown, then it is within the 90 days, 120 days.
Then, my lord, he should have filed the WS. Because I submitted the documents he received on 35/24. Sorry. 35/24. So from that, if it is counted from that date, then
Then his time is 27/9.
27/9.
Understood?
Yes.
But if it goes back to the stage of 19/9,
Yes.
the day on which the court proceeded ex parte, then if that is the date on which the court relegates the proceedings back to that stage, then wouldn't that be within the 120 days?
My lord, in my response submission, even if the proceeding was fixed for ex parte hearings, then also the petition for vacating ex parte order could have been filed by him because what he was doing within that date. And he has not mentioned the petition as to on which date he came to know that the suit is proceeding ex parte. From the petition, revision petition, nowhere it is mentioned that on which date he came to know that suit is proceeding ex parte. Furthermore, my lord,
The proceeding ex parte is clearly given on 19/9. That is the order.
no, he has not stated that because he is saying that he was unaware of that date because of the wrong posting in the diary. Now, on which date he came to know that there was wrong in the diary? That is not mentioned. So at least that petition for vacating ex parte proceeding and for filing WS could have been made by him within that period also, within the period of 120 days also. And he could have filed the petition for vacating ex parte order prior to the date fixed for this ex parte proceeding.
On 29/11.
Yes. And he has not done that. And as regards his court diary, he's saying that there was mistake on the part of him by misquoting the court diary. The court diary page is not available here. How can he say that this he should have annexed that there was a wrong posting? This was the date already fixed. I posted on such and such day. He could have annexed it, but he has not done that. So how can the honorable court can know that whether this was misquoted or not in his advocate diary?
Affidavit, petition filed by whom? Order 9/7.
Filed by him.
Filed by the defendant.
Where is the petition?
38, page 38.
No. At page 38, he says when he came to learn.
On 25/9, yes.
Ah.
On 25/9. अच्छा, ठीक है. On 25/9, he came to know. So he came to know when 25/9, on 25/9/24, he could have filed the petition for fact ex parte proceeding and he could have filed WS on that date also. Or say 2 or 3 days after that also. But that he has not done. Then if he could have filed the WS with the petition within 12/11, then that would have been within time. He came to know on 25/9. So what he was doing from 25/9 to 29/11?
He was acting as per the engaged counsel's advice.
My lord,
He was acting as per what the council advised.
my lord, I don't think that any council will advise like that. That the 2 months you enjoy and thereafter you will file the petition.
Where is your objection?
My lord, I have not. I appeared today itself. I have not filed.
No,
yet
no,
objection.
no, there. Before the trial.
I verbally objected. I did not file written objection. I verbally give my oral hearing.
So therefore, if you have not objected it, then the
In the
cause
in the
if
out-
it
in
is
the
a
order sheet,
good
it is
cause.
in the order sheet mentioned that it is objected.
See, you have objected it.
Yes.
You can object on what? On the basis of the records,
Yes,
as well as on the basis of legal submissions.
my lord.
On facts, you cannot. Unless it is written. There is no
On facts,
denial.
but I have some objected on the basis of records and on
On the
legal
basis of
submissions.
records
Yes.
and legal submissions. So the fact that he had not done it, the council made the mistake, is not denied.
My lord. My simple submission, my lord. The petition does not speak, even before the learned trial court, as well as before this High Court also, as to what he was doing from 25/9/24 to 29/11. It was his duty also to indicate that. Even if I,
Council, Mr. My therefore question is, Order 9 Rule 7 still continues to hold the field even after the Commercial Courts Act have come into being. So
I'm
therefore,
not denying that.
applying the judgment in Sangram Singh, it will go back to the date of 1990. And if it goes back to the date of 1990, it is within 120 days. Have you seen my order? Huh?
Unfortunately, I have not seen that.
No, the
This
order
what-
which
yes,
has been
this-
passed.
yes, I have seen this. I've seen this. I've seen this.
So therefore, couldn't it come within the period of 120 days?
I leave up to your lordship.
No, you don't leave it to me. Why I'm
But
saying
in
is
my
that-
submission, my lord, the petition which he has filed, as per me, was not maintainable because there is no explanation in the petition regarding regarding 25/9/24 to 29/11/24.
explanation is there to the fact that there was a wrong noting by the council. And the council waited. And he waited till the next date on 29/11. He could have filed it on an off date. There's no quarrel with that. But would it be proper for this court to be so hyper-technical? Because this is a commercial suit. So one has to be very strict also. One cannot be so lenient also like any other case. So therefore I'm asking you.
But order 9, rule 7, I do not object. The provision is there. It will take back to that.
No,
date.
if order 9, therefore I'm asking you, the moment order 9 rule 7 applies, wouldn't it go back to the date of 1990?
That will go.
If it goes now to 1990, you see the language use, it will go back to the 1990, then on that very date, it is not 120 days.
Yes, on that date is not 120.
But I want this further submission on this because of the fact, if I pass that order, this is a new type of thing which has happened. It may open up various loopholes to this mandatory period of 120 days. So I need to be very clear on this. Like that day, I didn't allow one matter of Mr. Bhatti for getting an amendment. He wanted to amend it by bringing in account another party. That party, when it came in, there comes section 12A of the commercial, which has been made mandatory, means pre-litigational things. So one has to be very strict when it comes to a commercial dispute. So can it be done so? When more particularly the Supreme Court has made it very clear that you cannot go beyond
120 days.
That is the only worry. Because if I give this chance, every time they will come up
Yes, ma'am.
and come up with a good cause and then take it, the benefit of this. For this matter, it is okay. I pay I'll put them, ask them to pay a cost of 35,000. But can that be the law, proposition of law? I will hear this again after vacations. Because this is a very important step. Because every time a person will take that benefit and show a good cause. And this, you see, this is a Order 9 Rule 7 gives a very liberal, it's a very liberally to be construed compared to Order 9 Rule 13. Now, if it is a liberal construction is to be shown, then if it dates back to that, then the mandatory period of 120 days is being taken care. They address me on that.
Meanwhile, I will file my affidavit, madam.
Huh?
I will file my
No,
affidavit.
affidavit not required. Affidavit, here the question of affidavit
No,
does
no.
not arise. I'm only on the legal perspective. How do you take care of it? Because it will open floodgates with this order.
No, not in August then.
Huh?
In August. Any date in August.
The issue involved in the present petition raises a important aspect touching on an interpretation to Order 9 Rule 7 of the Code, read with the provision of Order 8 Rule 1 insofar as it is applicable to commercial suits. As the matter would require further deliberation, list the matter on 11th of August 2025 for further hearing. The interim order passed earlier shall continue till then.
Obliged.
What is it?
Notice.
Oh, that one. Your application was rejected.
They had filed an application that was allowed
Oh, Section 8.
and for the plaintiff petition.
Why was it allowed?
My lord, they had filed a WS.
Uh,
After that, they had approached,
Oh, they have also not enclosed the photocopy. Original also, neither certified copy, nothing has been done.
after filing the-
WS, he said. Yes. How is it possible?
My lord, they have filed that agreement, my lord, this agreement.
So,
Well,
when it is on the record, my lord, they have admitted it. Your losses may see page, for. Annex
No, no,
three.
no. First you answer on the question. After filing the written statement,
Yes.
how could you file it?
No, I have not submitted the jurisdiction, my lord. There, I have taken the plea, my lord, that.
No, no, the language used out there is before submitting the first statement
lord,
of defense.
That has also been, my lord, interpreted, my lord, that whether I have submitted the jurisdiction, that, but the written statement, per se, my lord, is not the thing. My lord, here, we have taken the plea that this matter is not maintainable because in terms of, clause 19 of the agreement. Your losses may see the written statement.
No, no, maybe, but then also that is but without submitting the first statement of defense, how could you do that?
My lord,
That's the language.
no, that is language, my lord, but that is interpreted, my lord. I'm just referring to a matter, my lord. My lord, 2011 5 SCC 532, my lord. Your losses may just see paragraph 25. Section 5 still say, my lord, that.
Huh?
No. 25, my lord. Not only filing of different statements, but filing of any statement.
Page, paragraph?
Paragraph 25, page 543.
Not only filing of the written statement,
Statement
is
of
good,
truth,
but filing of any statement, application
by the defendant prior to filing of the
will be considered
statement
submission
will
only.
be constituted
By
as submission of the
filing of the
statement of
amend,
the
the
substance.
defendant shows
of
his
the- so
intention
if
to
by
submit
filing a
himself to the
statement application of
submission
affidavit,
and waives
the defendant shows his intention to submit himself to the jurisdiction of the court. And waives his right to seek reference to.
No, 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 this is a different. For
Huh?
an injunction, there is another judgment of that. This
No,
is the
no,
judgment of
my lord,
another.
Here, my lord, my
That
question
is the Raष्ट्रीय Ispat Nigam's thing, wherein when you file a reply to the injunction application, it would not be construed as submitting a statement of defense.
So, well, that is one aspect. But even in written statement also, if we take the plea, well, suppose.
Where is it? Show me the way the Supreme Court
Well,
says.
I have submitted a written statement. Written statement, I have still taken a plea, well, that this suit is not maintainable in view of, well, so preliminary issue can be filmed also, well, on that point. On that same thing.
Section 8 application could not have been allowed when you have submitted the written statement.
My lord, there are, my lord, this, lord, and there are division bench and single bench judgment of the High Court also.
Wherein it says, once written statement is submitted, then also one can do it.
My lord, this is a division bench judgment of the Delhi High Court.
This is a single bench judge.
My lord. No, this is division bench.
What division bench?
Division.
Where?
That forum.
Forum is what?
Rajiv Sahai and Rajiv, oh, sorry.
Then?
Wait, my lord.
Where is it?
Now, here, my lord. Paragraph 17, my lord, your lordship may come. After considering the list in itself. In my view, the said legislative intent requires the court to interpret the section as widely and not in constricted fashion, as would the case if it were to be held that though by filing a separate application simultaneously with the filing of the written statement, reference to the arbitration could be made, and but not if the plea is to the same effect is taken in the written statement, or if it were held that absence of a prayer in the application for the written statement referred to the arbitration could not take away the right of having disputes executed as agreed mode of arbitration. Similarly, in Kalpana Kothari, they say, now, Then, my lord, your lordships may come to paragraph 20.
Paragraph?
Paragraph 20.
Yeah.
B, my lord, your lordship may see. There he had no judgment. Prasanna Gupta has been held that a plea by way of preliminary objection, the written statement contesting the jurisdiction of the civil court to proceed to the suit for arbitration, even though referring to section 5 and not section 8 of the Arbitration Act, is a plea within the meaning of section 8 of the Act, and the defendant cannot be said to have waived or abandoned the.
No. No ground.
Hello?
It does not say.
My lord, the section 5 also says, my lord, section 5.
5 says that.
Well,
No proceedings should be
My lord,
judicial difference.
Now, my humble submission, my lord, whether it's a case, my lord, where your lordship is interested.
Where you have not raised that plea,
My lord,
where you have not filed the section 8, how can you file this?
my lord, in the written statement, I have still taken the plea, and that was considered by the trial court. My lord, if your lordship sees the review order.
Now, show me the written statement
My lord,
where you have taken the plea.
yes, written statement, my lord. Your losses may come to written statement at page 155. At page 158, my lord. 158. Paragraph 18. That the present suit is not maintainable in terms of clause 19 of the agreement, where it is agreed that any dispute on the question whatever arising between the parties shall be referred to.
This cannot be section 8.
Well,
This cannot be a ground taken on
Well,
that basis.
No, I'm not submitted to the jurisdiction of the court, my lord. I've said that, my lord, in view of,
You are submitting that the suit is not maintainable.
yes,
That would not be a ground.
no, not maintainable, I have not said, my lord. Between the parties shall be referred to arbitration, my lord, it says.
Yes, submitted. You should have said that the written statement is filed without prejudice to your rights under that agreement. You have not.
My lord, I have no submission, my lord, that I have not submitted openly, my lord, to the jurisdiction of the court. I have reserved my right, my lord, saying that there is a clause of arbitration and if their matters to be referred to arbitration. And thereafter I filed the petition under section 8, my lord. So that, my lord, your losses may broadly interpret, my lord, this section 8, my lord, whether I have submitted to the jurisdiction of the court, my lord. If I have not submitted to the jurisdiction of the court directly, my lord, reserving my
You
right.
said it,
My lord,
that you do not submit to the jurisdiction of the court in view of the arbitration clause.
my lord,
And reserve your right to file your section 8
my lord,
subsequent.
that plea has been taken in the written statement. my
No,
lord.
no, that is not enough. Okay, so that is one gone. Now, secondly, why do you say about that? You don't have to bring the certified copy or the original when the mandate says, section 8 says? Show me that.
No.
Where is the judgment?
My lord,
to that effect?
when the plaintiff himself has announced the agreement,
So,
my lord. So it is admitted fact, my lord, why it is required, my lord, because only to see the court that it's a correct, my lord, position of the law, my lord, in the agreement. And that agreement has been announced by them, and that is at page 55, my lord, your lordship will see.
not satisfied. Chalo, dictation.
My lord, one more aspect.
I'm allowing a petition.
Yes, my lord. But
Then-
one-
Yes.
they have said like they have filed section 8 petition, my lord. The section 8 petition does not consist of a prayer seeking a referral, my lord. No referral prayer is there, my lord. As such, in substance, this is also not a section 8 petition, my lord, which they have preferred. My lord.
Where is that?
Page 174, my lord, the prayers are there, my lord. The petition is at page, my lord, 161, my lord. if my lord considers the prayers, my lord, 174, there is no seeking referral to the arbitral, arbitral tribunal. Page 174, my lord. The prayers are there, my lord. Only for the suit to be dismissed, that is there in substance. So this is not in substance of section 8 petition itself.
Is the dispute? What is your suit for?
My lord, I have been, lease agreement was executed, I have been put into possession, my lord.
Huh?
I have been put into possession on a plot of land, my lord. For the execution of the lease agreement. My lord. But originally they have put me in another plot of land showing, executing the lease agreement for another plot of land.
So what are you asking for?
I am seeking, my lord, declaration, damages and compensation, because they are not trying to oust me. And then they have also dismantled some of my property, which I had constructed upon the scheduled property. Now diverse things are going on, my lord. The circle officer is also backtracking and giving diverse reports. One before the police officer is telling I am upon another plot of land, while they have executed the lease agreement another plot of land, and they have put me into possession in another plot of land. An element of fraud is also there, my lord. As such, the trial court proceeding would be very much necessary.
When did you file the suit?
January 2024. day of January 2024.
What is the value? Value of the agreed consideration? Square feet. 1150 per square feet per year or per month?
For
Huh? Per month.
that per month.
Huh?
Per month.
How much it would be? 1150 per square feet would be? $3,200 square feet into 1150. Huh? Around
49.
per month. It is for 10 years.
Yes.
What should be the lease stamp duty for that? You have paid only 6,000 as the stamp duty. What shall be the stamp duty? Can this document at all be taken into account by the court? It couldn't have been 6,000 as stamp duty.
If required, my lord, this document can be impounded by the court, and then I may be allowed to pay the stamp duty. The trial court.
Because what happened is, this is to be impounded. The court cannot act on an insufficient stamp paper document, even for section 8 or section 11. There's a constitution bench judgment. Justice K.M. Joseph was there, who was the majority, and the concurring is by Justice C.T. Ravi Kumar. The minority judgment is of Justice Rishikesh Roy and I think Justice another one. So that is the constitution bench judgment. So this document could not have under no circumstances be taken. That is why he has not produced the original. Find out that how much would be the stamp duty. Because without that, without paying that amount, the question of applying this clause does not allow. On this ground only, apart from the other two grounds are there to make it more stronger for you. Discourse. Find it out. Mr.
My lord,
K.R.
there is another judgment of the Delhi High Court, my lord, your lord.
What is that? What does he say?
Sign, my lord. Paragraph 26, my lord.
Para?
Paragraph 26.
26.
Same. The earlier judgment also. Section 8 judgment specifies the manner in which party has to submit the first statement of dispute. Normally, with respect to suit, the first substance of the dispute, the defendant would be the detailed statement, because if the detailed statement file is brought to the notice of the court, there exists an additional agreement between the parties which embraces the subject matter of the suit. There will be no complete compliance with the mandate of the law.
Kindly come to paragraph 27.
Yes.
In the
Section is-
present case, the section 8 objection was taken by the appellant not just in the written statement, but even prior thereto.
Yes.
How does it apply?
So that's my lord, that objection, my lord, I'm saying.
Observations may make anything, has no relevance. First of all, it is not binding. Second of all, even that, if I have to consider it, also of no value. Mr. K.R. Borua, the learned counsel appearing on behalf of the petitioner, submits that even otherwise also, comma, the learned trial court could not have relied upon the unregistered document of lease in respect to the arbitration agreement, inasmuch as the stamp duty which was paid on the face of it was insufficient. He submitted that the lease was apparently was for a period of 10 years and the monthly lease amount was 49,000. Full stop. Therefore, the lease, the stamp duty has to be much more. Full stop. This court inquired with the learned counsel as to what would be the stamp duty. He submits that he would place it before this court after if some time is granted. Full stop. Accordingly, list this matter again on 13th of August 2025. Interim order passed earlier. Interim order is not there, na? The passed earlier shall continue till the next day. Yes,
So far the court is concerned, my lord, I have complied with the order.
very good. At last, there's something good. Yes, now tell me, what do you want?
My lord, only the status quo has gone. Let the appeal be admitted and status quo in respect of the two claims.
Who is in possession?
So far the position that is in the position of.
From 2003 onwards, you are not in possession. Then
That is it, my.
what
Only
status quo
change
you
the
want?
Character and nature.
Character
My-
means?
Character, nature of the.
What
building.
character? Where is the land?
It is situated at Amingaon,
So, Amingaon where? Agricultural land,
not industrial land,
industrial land.
commercial land.
So what character is he going to change?
But he may construct it, he may. All these things, only the character.
From 2003, he is in possession.
That is right.
Then-
I am not disputing that, and I am also not going to disturb the positions of the respondent.
You cannot unless you file a suit. And you have filed a suit for that. And he
Yes,
has filed a counterclaim.
counterclaim, that is there, but only limited there. That is only not to change.
Oh, I'm very stingy on this aspect. We'll hear the other side and do then, fight it out. This is an appeal filed under section, heard Mr. O.P. Bhatti, the learned counsel appearing on behalf of the. This is an appeal filed under Order 43, Rule 1R, read with section 104 of the Code of Civil Procedure, challenging the order dated 5/5/2025, passed in Midday case number 17/2023, arising out of title suit number 7/2023. Pusto. By the impugned order, the learned trial court, that is the court of the civil judge senior division, Kamru, Amingaon, had rejected the injunction application filed by the petitioner. Pusto. Taking into account the grounds of objection so taken, the appeal is admitted. Full stop. There shall be no necessity for calling for the records. Full stop. Steps be taken upon the respondents by way of registered as well as usual. Mr. O.P. Bhatti submits, the learned counsel submits that there is some urgency in the matter. First up, liberty is given to take steps by way of Dusty upon the sole respondent by routed through the registry of this court and file an affidavit of service on or before the next date. List this matter on when you are coming back.
In first week of August.
First week of August, okay. On 4th, 6th of August, 2025. First up, next. I is there?
Yes.
Is an application filed under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure 1908, seeking an injunction, temporary injunction, ad interim ex parte, taking an injunction, seeking an injunction, thereby restraining the opposite party, oblique respondents, his men, agents, servants, employees, etc., from changing the nature and character of the RCC building as described in the schedule thereto. Full stop. This court have duly perused the said application and taking into account that the learned trial court have rejected the said application, similar prayer, comma. It is the opinion of this court that without hearing the other side, passing of any injunction, any ad interim ex parte injunction would not be in the interest of justice. First of this court shall consider passing of any order on next date. List again on so and so. Ako ito the issue notice issue notice returnable on so and so. Steps be here registered as well as usual, and liberty given to take steps by way of dusty routed through the registry of this court. Sixth. Pending আছে. Good case, bad case.
Lots of good case.
Yes, what is this?
Lordship, this appellant, they prepared a suit for partition in respect of the ancestral property. Their claim was that the entire land is ancestral property. So during his lifetime, during the lifetime of their father, he sold out some portion of the land and some portion gifted to his sons. The defendant is the wife, the widow of his brother, their brother.
You are a plaintiff?
We are the plaintiff.
Okay, then what happened?
Then what happened?
What is your suit for?
For declaration of right and interest, partition, and for injunction, recovery of possession.
Recovery of possession.
Lordship.
You got it how? Right? Right is under how? You are the daughter?
Lordship, we are the daughters.
Oh, how is Abdul Wahab the daughter?
Lordship.
Abdul Wahab, Zahmin Wahab. So now what has happened?
Lordship.
And Srimati Nasim Banu.
Nasim Banu.
Who is he?
Nasim Banu is the Lordship. She is the daughter-in-law of the our father and of the plaintiff. Because the widow of their only one brother. Fariduddin Ahmed.
Okay, who is the father's name?
Nazimuddin.
Nazimuddin.
Lordship.
Okay. Father had son and daughter.
Father had 4 daughters and 1 son.
4 daughters and 1 son.
Lordship.
Okay. And
and
Man, wife.
wife.
Okay,
Now
then,
she is no more.
Huh?
Now the wife is no more.
okay.
The son also died.
Son died, did the son die before the father or
No,
not?
after it.
So therefore it devolved upon the father, son. Okay, then,
Now the defendant is the widow of that Fariduddin. Now what happened? Our case is that the case of the appeal and plaintiff is that during the lifetime of the father gifted, orally gifted 1 katha 10 lessons of land to his son, the brother of the appellants. Out of total land, 1 bigger 2 katha 15 lessons.
Hmm.
And out of the remaining land, 1 bigger 1 katha 5 lessons, the father sold out 18 lessons of land to one Abdul Rasid. It is undisputed.
18 letters.
18 lessons. And after he sold out again almost 2 katha 2.5 lessons, 2 by 5 lessons to one enamel. So it is also not disputed. Yes, land has been transferred. So according to that, total land remains 3 kathas, 6 point odd lessons of land. So thereafter, the son, Fariduddin, who was the owner by way of oral gift 1 katha 10 lessons of land, he also sold out 1 katha 4 lessons of land to one Taslima.
From these 3 kathas, 6 lessons.
No, Lordship, that is 1 katha 10 lessons out of which was gifted by the father to his
Out
son.
of the gifted land he sold out.
He sold them. It is the case of the case. So in total, their land remains only 3 katha 6 lessons for 6 lessons, because 3 katha 12 lessons remain unsold.
3 katha 10 lessons.
12 lessons. Almost 12 lessons. That is the total land as on date. There is a residential houses and structure. Now the claim of the defendant is that as per Jamabandi, we have both the parties exhibited the Jamabandi. As per Jamabandi, that exhibit A has been exhibited by the defendant side. We have exhibited exhibit 2. As per Jamabandi, that the father and son, Nazimuddin and Fariduddin, they were equally entitled to get their land. That is 3 katha 17 lessons and all. Out of 1 bigger 2 katha 15 lessons. That means half of the portion of the land belongs to Nazimuddin, half of the land belongs to Fariduddin.
Means during the lifetime of Nazimuddin.
During the lifetime of Nazimuddin. It is their case.
And I'm not on their case, I'm on your case.
No, my case is that Nazimuddin was the absolute owner. His son, Fariduddin, was the only entitled to get 1 katha 10 lessons, which was already gifted to him by his father. But case of the defendant is that no.
So you are asking for how much now?
Now partition of 3 katha 12 lessons of land.
Okay.
Because we are the legal heirs, he is also legal heirs. Yes,
But
properties to be
he'll go get 50%.
Lordship.
He'll get 50%.
Fariduddin. No, Fariduddin is no more.
It's the wife will get it.
Definitely.
Because
But
it has already devolved upon his father. Nazimuddin, Fariduddin, during upon the demise of Nazimuddin.
not the entire land.
Why not?
Half. That means 3 sisters, 4 sisters and 1 son.
Uh,
4 sisters and 1 son. That
So
means
the,
4 plus 2.
No, it will go as per the this Mohammedan law of succession.
Law of succession. That means law
How
of
much?
succession. Son will get double.
Double.
Double. That is 4 plus 2. 6.
So it has to be divided amounts by, he will get 1/3.
Not
He'll get 1/3 and remaining will be 2/3 will be them.
10. No, that question was not considered at all. The case of the defendant was that during the lifetime of Nazimuddin and Fariduddin, both were owner, the equal owner of the property. And out of the share, there is 3 katha 7 lessons, which according to them belongs to Nazimuddin. He sold out 18 lessons and 1 katha 10 lessons, or 2 katha so and so. He remained only 1 katha of the 19 point odd lessons of land. And that 19 lessons of land orally gifted by Nazimuddin to his son, Fariduddin. And Fariduddin, who was the owner of 3 katha 17 lessons of
He
land,
remained the owner.
Not, he became the owner. So entire land belongs to become the Fariduddin, and Fariduddin during his lifetime sold one kata forest of Taslima, and the remaining land he already gifted during his lifetime to his wife, that is his defendant. Her name is Nasim Manu Ahmed. So she became the owner. Now this person is not the owner of the property, so they have no right. So learned trial court considered the Jamabandi, that yes, as per Jamabandi, the entire land is divided in equally. There's no comment to that effect. But as per Jamabandi, 3/7 has been bifurcated. And accordingly, Farid is the owner of, Fariduddin Ahmed was the owner of 3/7 acres of land. Najimuddin was the owner of 7 acres of 3/7 acres of land. Najimuddin admittedly sold out so and so land. He remains only 1 kata. And according to Najimuddin was the 3/7 acres. So this is the position. And when their basic claim is on the basis of the oral gift made by Fariduddin
So
to his wife,
otherwise also wife gets it.
that's it.
Otherwise also wife will get it.
He will get a share.
Then
His share.
he say no, if it is belongs to Fariduddin, the succession will not go to the sisters.
Brother's share. Definitely some of the portions.
Where?
No.
No.
Definitely it will not go. Definitely not.
Now both the courts have held it against you.
Against me holding that they are owner of this so and so land, they have an oral gift.
Mr. Bhuya, your case is bad.
No. One. Lordship, their claim is that in paragraph number 19 of the written statement, I am claiming. Paragraph number 19 of the written statement, page 38. That the husband of the defendant was suffering from ailment continuously 2 years prior to his death and almost 1 year prior to his death in presence of the plaintiffs. Plaintiffs, brother of the defendant and other declared donated the entire suitland and premises standing on the suitland in favor of the defendant. So that is the oral gift. All right. Now, how she has got her name mutated? By way of inheritance.
So,
As per,
no, let us assume. Let us assume you have not made these Fariduddin's sons and daughters party.
no, she has no done, issueless.
So issueless. So therefore, by way of succession, the wife gets it.
Definitely she will get
So
it.
whether it is gifted
Not
or
the
not, how
entire.
does it relevant?
Not the entire.
Who will get it?
Definitely,
Brothers?
Father's share is 3/7 letters.
Forget about that. I'm not that. If it is 3/7 letter, is taken as the share of the Fariduddin, and 3/7 letter belong to Nazimuddin, the father, which is the finding of fact right there.
Yes, it is assumed
So
by-
therefore, 3/7 letter, which remained after some deduction, some sale being made by Fariduddin during his lifetime. So it remained with the what do you call the
What?
wife. So that portion the wife will get it.
If it is 40, I mean, it is assuming that she will entitled to get it. By way of
By-
inheritance or by way of.
In-
So for the Nazimuddin share is concerned, remaining share, assuming that yes, Nazimuddin was 3/17 letters
So
of.
there will be something which if Fariduddin didn't get, then the question of there being a little bit of some land transferring to the plaintiff will arise.
Yes.
If Fariduddin did not get this 1 kata 19 lecha,
Lord.
that's your case.
And
Then
when,
your substantial questions of law are
no,
what?
regarding perversity, why I am taking the
No,
perversity,
perversity for what?
I am coming to that. Their specific claim is that it is an oral gift made by Nazimuddin. Sorry, Fariduddin. And there is a Nazimuddin is there is an oral gift. And therefore entire land has been gifted by the Fariduddin to his wife in presence of his brother plaintiff. They examine the brother of the plaintiff as DWP. During his prosecution, what he has stated, regarding the gift, I have heard it, but she had inherited property by way of inheritance. Then, is it not part of law?
Why?
Because claim it that he is entitled to get the,
No. Regarding the gift, to whom?
to Nasimuddin, sorry, Nasima. Why?
Nasima, forget about Nasima. We are not concerned with Nasima. This one katha 19 Lesa is the gifted land by Nazimuddin to Fariduddin.
Not only only one katha.
Whatever may be, that
Made.
is the land which you
That's
are
the oral gift.
claiming.
According to them, the oral gift made by Nazimuddin. To
Nazimuddin.
his
Now,
son.
now on the basis thereof, what is the proof?
No,
What no?
they have not mutated their name by way of, neither Fariduddin got his name mutated by on this date of gift, nor the subsequent, the donor, that is Nasima, also did not get the name.
Nasima doesn't have any
Now,
relevance.
so major share is
The
concerned.
only right you have is only on those one katha 10 lecha or 19 lecha.
Got it.
So that was the land which could have been also their part of it. They may
Got it.
have some say,
Got it.
provided there is no gift by Nazimuddin in favor of Fariduddin.
So
Now, what is the
if there
evidence
an
for
oral
that?
gift, then offer tax is required. What is the offer tax? 152 subsection 3, your lord. Assuming that father and son resides there, where donor and donee both reside in the property, all right, they are residing in the property. No physical differential or formal entry is necessary in the case of a gift of immovable property in which the donor and donee are both residing at the time of the gift. In such a case, the gift may be completed by some offer tax by the donor, indicating a clear intention on his part to transfer possession and to divest himself of the control over the subject of the gift. Now, assuming that all right, that the gift has been made, why the part? Not offer tax, but he could have mutated his name in respect of the remaining land of Nazimuddin. He did not. He did not. That remained in, still that land was remained in the name of Nazimuddin. Subsequently, what happened? After the death of Fariduddin, entire land has been mutated by way of inheritance in favor of Nazimuddin. Though they are claiming that is a gifted land, this is the offer tax is required to be done. So that is one substantial question I have suggested, Lordship, that offer tax. What is the offer tax? And there is a decision that offer tax means mutation. At least they could have mutated their name.
This number 3 does not arise.
Lordship. Regarding Lordship. No, Lordship.
1 also does not come. 4 also does not come. Limited to
Lordship, offer tax. Lordship.
only to that. Being in the vacation mood, I'm in a good mood today. Okay. But Mr. R.K. Bhuyan, the learned counsel appearing on behalf of the applicant. There's an appeal filed. The section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 4/9/2021. 4/9.
Lordship.
Past. It's not yet been admitted.
Lordship.
Why? No. Between the judgment dated, no, 22nd of May 2024. Passed in title appeal number 6/2021.
One word.
Stop. The instant appeal is admitted on the following substantial question of law. Whether the courts below were justified in coming to the conclusion that the gift made by late Nazimuddin Ahmed of this you have admitted at paragraph 3 of the plaint. What is there?
One kata 10 lessons.
No, that is the one. Remaining is his finding of facts.
One kata 10 we have admitted.
We don't require anything more. You see, 3 kata 7 lesser was which is there. It's a finding of fact arrived at on the basis of evidence. One after selling up all the land, 1 kata 10 lesser was the land which was with the plaintiff. You see, what is your claim at best? First, your claim is the entire land belonged to Nazimuddin. This aspect, the court has said no. On the basis of the evidence, both courts have come to a finding that 3 kata 7 lesser, 3 kata 7 lesser belong to Nazimuddin and Fariduddin. Sure. Out of that, the court have come to a finding that out of these, there has been certain sale which have been made as very well stated in your plaint itself. Now, whether Nazimuddin and the Fariduddin have sold, gifted the land to his wife, or it has gone by the succession, the sisters have no business. So this is 3 kata 7 lesser gone, or whatever may be after sale. As regards the 1 kata 10 lesser after the sale by Fariduddin, Nazimuddin, you admit in your plaint that there was a gift.
My case
What is there to prove?
my case is different.
Your case is
How to
different.
tell them?
Therefore, the findings of fact.
Not the one in their question, although the finding of fact, one question is to be considered by the Honorable Court. That when they are claiming that land was mutated in the name of both the persons in the year 1962. And during that time, that Nazimuddin, Fariduddin was only 8 years old, 6 years old.
So, must have been purchased in the name of his son.
That was not established.
But you never challenged it at that point of time. At any point of time till 2020.
Their admission is there, Lordship. At that time, he was, at the time of death, he died in 2009. At the time of death, he was 50 years old. And if it is 50 years old, he was only 6 years old at that time. How he can be honorably equal?
Maybe the father must have given it.
That the document is
But you have not challenged that.
stated that he is not the owner of 3 kata 7 lesser.
No. You all along it has been. This is the finding of fact. Arrived at. So therefore, this 1 kata 10 lesser also doesn't remain because it is paragraph. You have paragraph 3 of your plaint. You have admitted. So therefore, 3 kata 7 lesser plus 1 kata 10 lesser is already there. Fantastic. No goes. Dismissed. I've asked you not to do the matter.
So for the gift is concerned, either from the Nizamuddin side or from their side, total gift is there.
No, you have admitted there is a gift of 1 kata 10 lesser.
1 kata 10 lesser, it is there.
Then?
So for the gift of Fariduddin is concerned.
Fariduddin is the owner. After Fariduddin dies, it is only the wife will get it.
Definitely.
The sisters have no business.
Listen, I have to put that question because Sunil, that
Give me something.
Mr. R.K. Bhuya seeks for some accommodation, list the matter to be. I told you not a good case.
Lordship. I'll try, Lordship.
Because I would have done it, but in paragraph 3 you admit.
Yes, I am admitting.
So there the problem arises. You have been more outright in your plaint.
I'll try.
But in this case, your lordship will largely directed us to take step by step. Accordingly, we took step and the issued by the registry on 16/6/2025. And when the petitioner went to the place of residence, he resides in a flat. The flat owner, they came to know that the respondents are temporarily shifted to the Calcutta. And we have collected the address of the Calcutta.
Where is the petition filed before the trial court, first appellate court, under order 41 rule
No,
27?
petition was not. It is court show moto.
Was that taken as a ground of objection that this particular document was not allowed, or this evidence was not allowed?
No, there is nowhere it is stated. Page 67, your lordship can see. That was it.
Service complete?
My lord, your lordship directed us to take step by step.
You have taken?
But last day we got the order, got the notice from the registry. But when we went to the to place a residence, he resides in a flat. He resides in a flat. When we went to her place of residence, the flat owner told us that she has temporarily shifted to Calcutta. And we have collected the Calcutta address. So we may be directed to take steps in the Calcutta address by register.
It has been submitted by Mr. A.C. Sharma, the learned senior counsel, appearing on behalf of the appellants, petitioners, that respondents presently reside at Calcutta, as the petitioners could only recently come to learn upon effecting service by way of dusty in the address as mentioned in the instant application. He therefore submits that he would like to take fresh steps by way of dusty in the address at Calcutta of the respondents,
As well as by register.
as well as by registered post. The address. He therefore submits that he may be permitted to file a fresh memo of parties also, putting the present address of the respondents in the instant petition. Taking into account the above, the petitioners are directed to the counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court, incorporating the present address of the respondents. List this matter on 13th of August 2025. In the meantime, the petitioners are directed to take steps on the present address of the new address of the respondents at Calcutta by registered as well as registered post. In addition to that, the petitioners are also directed to take steps by way of dusty upon the respondents in the new address of the respondents at Calcutta. First of the interim order passed earlier shall continue till then. Yes,
May it please your lordship, I am appearing on behalf of the standing counsel, Mr. D.K. Bordole, for the petitioner in this matter. Lordship, I have filed the transfer petition
yes,
praying for the transfer of divorce case, number bearing 24/2024 from the Honorable Additional District and Session Judge Dibrugarh to the Honorable Principal Judge Family Court, Guwahati, at Guwahati. Because Lordship, I reside at Bongora, Kamrup, and I also have a minor child, so it is very difficult for me to appear there. Plus, I don't have any source of income.
some cases pending here.
Yes, Lordship, the maintenance case, I filed a maintenance case at Kamrup.
Is he appearing?
Yes, your Lordship.
Who appears for the other side? Is the name being shown in the cause list? R.S. Mishra, M. Nirola, R.K. Mohanto. Where are they? None are there. Hello? You are enjoying an interim order? None appears on behalf of the respondents on call in spite of their names being reflected in the cause list. দেখা যাচ্ছে না? নাম আছে না respondent? আছে, পুস্তক. For the ends of justice, the matter stands adjourned to be listed again on 4th of August 2025. Pusto, it is observed that if on the next occasion the respondent is not represented, this court shall pass appropriate orders in that regard. And shall proceed ex parte against the respondents. Pusto, the interim order passed earlier shall continue till then.
My lord, we are challenging the order passed by the civil judge wherein amendment was allowed. We are the defendants who have filed a counter claim. In the counter claim, my lord, we had specifically indicated that we are in possession of the property. Now, what happened, my lord? After 14 years, they filed an application that in 2023, they are being dispossessed. So 2009, there is already a certificate from the circle office indicating that we are in possession. That is our specific case, that we are in possession and we are the owner. So now what happens in 2023, they file an application indicating that the crop has decreased. So we found out that property has been taken.
Huh?
They say that the crop has decreased. That is why they have learned that the property has been taken.
Where is their petition?
Petition, my lord, is 75. My lord, may come to page 80. Five, my lord.
What is the stage of the suit?
Yeah. Plaintiffs have been cross-examined. Now defendants' evidence has been filed. We are to be cross-examined.
Your Honor's file, what he says, the plaintiff states that after filing of the suit, the plaintiff has been utilizing the land for cultivating, and the defendant has not disturbed the plaintiff in its use and occupation of the, but since the month of June 23, the director of the company felt that the quantity of the deal is brought by for processing of the factory every day is substantially reduced. And in the prayer, Your Honor, the entire tea state, they need the possession. The entire tea state's land they need in possession.
Issue for a schedule below.
Yes, madam.
What is the schedule?
Schedule is that entire land, 581 bighas of land. It is not a case of 1 katha, 2 kathas or 1 bighas of land. My lord may come up to page 64, which is the certificate issued by the circle man. And this certificate is the exact schedule A, which the plaintiff is asserting for possession. We have taken a specific stand, my lord, in page 50, para 8, that we are in possession of the suit property.
You are claiming adverse possession over the whole land.
My lord. It is absolutely in my possession, my lord. My lord, see the order at page 103. The operative partner.
And what is your counterclaim?
Counterclaim is for adverse possession, my lord. Confirmation of possession and now what has happened, man, after 14 years, they come up and fine morning, they file an application that now we have learned that you have taken up possession. Now, my lord, for a practical purpose, my lord, how can we take possession of 581 acres of land in overnight? Suppose if you are not in possession. And there is already a certificate of 2009 where the circle officer confirmed that we are in possession of the property. That is my specific case. How can they take away my right by way of an amendment?
I'm not taking away your right. He's asking for recovery of possession.
But my lord, in the first, when they file the plaint, they say that they are in possession of the property.
So now they have realized that they are not in possession because they were not getting the tea leaves.
But if in 2009, they were getting tea leaves in 2023, how come they're not getting tea
They are
leaves?
getting less tea leaves.
My lord, that is, the entire suit land is there. It is not their case that part of the suit land has been taken up. It is absolutely 581 because of land, my lord.
Are you saying that this company has only 581 bigas
They may have more land. We are not,
in this garden?
that we have to find out, my lord, how much
No,
land is
no,
there.
I'm
But,
asking you.
but we are
That
in possession.
581 bigas may be a part of it.
We are in possession of 581 because of land, my lord, and this we are in possession since more than 30 years. Now, what has happened?
No, understood. Whether you prove your adverse possession or not prove it, he is going to prove that he needs a recovery of possession. So how does it matter? You are in a position. Your basic idea is that he has extinguished his title. Therefore, you say that you have a right to get adverse possession, a decree on adverse possession.
Right.
You get it. He is fighting for that. Let him go.
My lord, can, my lord, at this juncture, can this amendment be allowed?
Why?
My lord, they come up with a story that in 2023 June, they learned that the tea leaves have decreased, my lord. My lord, may kindly appreciate that in 581 bigas of tea plantation, how much tea leaves will be produced? It is not that 5 kg, 10 kg or 200 kg. 581 bigas of land is there. And the application, my lord, may kindly see what they say. In the amendment application, my lord, kindly see what they assert. The plaintiff state that disputed land is adjacent to the labor line of the plaintiff estate. The people living in the labor line has stated that the plaintiff, that the defendant man encroached upon the land since the month of June 23. Page 78, ma'am. Para 8.
The tea garden must be in acres, no?
It might be in acres, my lord. My specific case is that I am in possession of that property. Now, if they seek an amendment in 23 that possession has been taken up, so my adverse possession gets futile, my lord.
Why? How does it become different? How does your adverse possession plea is being taken away?
My lord, when the trial has commenced, a person comes up with a concocted story on principle also, my lord. My lord, may kindly appreciate that.
How do I decide the concocted when the trial court says that he believes him?
No, my lord, the trial court has not indicated in that manner. Trial court has said that it is a subsequent event, so we incorporate.
Yes. Whether it is a subsequent event or not, it is for him to prove it.
But whether after the commencement of trial, such kind of amendment.
Are you submitting that after the commencement of trial, there cannot be a subsequent
No, my lord,
event?
that is absolutely not my submission.
Then?
That is absolutely.
No interference.
My lord has already taken care of that LIC judgment in not many cases where in para 70, my lord, they specifically indicated my right is taken up. I am in possession. Now they assert that my right has been taken up.
So they are trying to show that in June 2023, your possession has been taken.
Hmm.
Whereas your case is in that you have been in possession. We'll prove it. The falsity of their case is proved. Now, it becomes more difficult when they are getting that decree. Now, once you prove it, that you had all along the possession prior to that. So it is become more difficult now. They say now it has been only happened. So they have to show something must have happened in the meantime by evidence. Not so easy. You have a right to submit your written statement. I can do only one thing, impose a cost upon them 50,000. That is the only thing I can do. 50,000.
My land was enclosed, sir.
Huh?
My land was enclosed by them. So that I am paying 50,000 for that.
Dr. Sharma, tell me one thing. How much land has been enclosed from?
That, the schedule alone, that 540.
Where is your prayer for Schedule A?
Prayer.
Recovery of what land? The
That-
Schedule land,
Schedule land.
which means 581 plus 11 bighas. Isn't it?
Yes.
So what is your tea garden size?
The size I don't know what it's big.
Huh?
It's a small portion.
Huh?
That 581 bigha is a small portion of that. Piece.
What is your name of your tea garden?
Athoni tea estate.
Atholi.
Athoni. And the petitioner is Dolaguri, both are adjacent. Earlier, the same owner was there of the both the tea.
Oh, they have encroached you. Now the suit will be, they have to file again written statement. In your written statement to the counterclaim, what did you say? You were
I
in
didn't-
possession.
No, I was in possession. No, no, my lord. They have absolutely stated that it is in their possession.
That is what they
Ah.
said.
They say that it is in possession.
Mr. A.K. Sahib, the learned counsel appearing on behalf of the petitioner, Mr. R.K. Sharma.
Arson.
Sharma appears on behalf of the respondents. Gustav. The jurisdiction under Article 227 of the Constitution has been invoked, challenging the order dated 15/6/2024, whereby an application filed under Order 6 Rule 17 being registered and Ms. A case number 28/2023 arising out of title suit number. Title suit
of nine.
number. Huh?
6 of 9.
People, they don't write the title suit number also.
That's number 6 of 9.
6/2009 was allowed. The question therefore arises as to whether this is a fit case for exercising the jurisdiction, supervisory jurisdiction of this court. It is seen that the plaintiff herein, the respondent herein as plaintiff had instituted a suit being title suit number title suit number 6/2009, claiming inter alia, seeking a decree for declaration of their right, title, and interest over the land described in Schedule A to the plaint for confirmation of possession over the said land, as well as for permanent injunction. Gustav, the plaintiff also sought for a demarcation of the boundaries, etc. Pursuant to the filing of the written statement, plaint, written statement was filed, wherein the defendant, wherein the manager of the defendant, a manager of the defendant, who is the petitioner herein, have not only filed a written statement, but also filed a counterclaim claiming right title and interest on the basis of adverse possession. Full stop. The petitioner, the respondent herein as plaintiff had also filed a written statement to the counterclaim claiming inter alia that the question of the petitioners herein oblique the defendants having right title and interest over the adverse possession does not arise in view of the fact that the petitioner, the plaintiff was in possession of the suit land. Full stop. It is seen that at the time after the evidence have been adduced by the plaintiff oblique the respondent herein, comma, and at the stage when the suit was fixed for filing of the cross-examination of the defendant witnesses, comma, the plaintiff filed an application under Order 6, Rule 17, stating inter alia that in the month of June 2023, when the in the month of June 2023, when the director of the plaintiff company was made an inspection, it could be found that the plaintiffs, the defendants oblique the petitioners herein have encroached upon the entire suit land, and as such sought for amendment of the said plaint by inserting paragraph 5A and 5B, and also seeking amendment to paragraph number 7 and the relief of recovery confirmation of possession was to be substituted by a decree for recovery of possession. Full stop. Written objections were filed by the petitioners stating inter alia that the entire allegations so made in the application filed under Order 6, Rule 7 are false and mischievous, and that too, the same have been sought to be done after 14 years of the suit, after pursuant to the filing of the suit, and that too, and more particularly, when the suit was at the stage of evidence. Full stop. The learned trial court, by the impugned order dated 15/6/2024, allowed the said application seeking amendment on the ground that these are that these that the on the ground that the cause of the details which the plaintiff seeks to insert by way of amendment are subsequent events which took place pursuant to filing of the suit, and as such the same is required to be inserted, thereby allowing the amendment. Full stop. The petitioner being aggrieved have therefore approached this court. The defendant, who is the petitioner herein, have been aggrieved, have approached this court by filing the present proceedings. Mr. A.K. Saivara, the learned counsel appearing on behalf of the petitioner, submitted that the written statement as well as the counterclaim which was filed in the year 2009 categorically showed that the petitioners were in possession of the suit property, full stop, and on the basis thereof have sought for a decree for recovery, a decree as regards right title and interest on the basis of adverse possession, full stop. The learned counsel further submitted that by way of permitting this amendment for for recovery or possession at this stage, have nullified the rights which have been created in favor of the defendants during the pendency of the suit. This court have duly taken note of the order which have been passed by the learned trial court. And further, it is the opinion of the learned trial court that these were subsequent events which had happened in the month of June 2023, and as such, the amendment was required to be allowed. First of the question as to whether these events have happened in the month of June 2023 is a fact which the plaintiff has to prove in the course of evidence. And under such circumstances, has to prove first, be that as it may, this court is not inclined to interfere with the impugned order. However, this court would make an observation to the effect that the findings so arrived at by the learned trial court in the impugned order dated 15/6/2024 should under no circumstances be construed as an order deciding that the plaintiff was dispossessed plaintiffs were dispossessed in the month of June 2023. First, the said as was at the cost of repetition, it is observed that the said shall be subject to the findings arrived at on the basis of evidence. So considering the above, this court disposes of the instant application. Full stop. The amended plaint, there was a stay.
Yes, Lord.
Full stop. This court further vacates the stay order dated trial court records POM. Trial court records POM. Isn't Scan or original?
This is only the miscase record, Lord. Only the miscase record.
Very good.
Yeah, order
The
number
interim
2820.
order stands vacated. The interim order dated 2/8/2024 stands vacated, and plaintiffs oblique the respondent herein is directed to file their evidence their amended plaint on July 14th, 2025. Full stop. This court further directs both the parties to appear before the learned trial court on the said day on July 14th, 2025. Full stop. It is observed that if the amended plaint is not filed on July 14th, 2025, the consequences under Order 6, Rule 18 shall ensure. Full stop. The trial court shall give due opportunity to the defendants to file additional pleadings in view of the amendment. LCR return. Yes,
Your Lordship,
we have taken steps.
we have taken steps through Dusty service, but we could not file the affidavit today.
We vacate the order. What is wrong? You are not being able to serve it. What?
The petitioner is residing in Bongai House.
You stay here. The respondent resides at Guwahati. Why you are not doing it by yourself? We impose a cost of 10,000 upon you. What's your name? Huh?
Espal.
No, upon you. 10,000 rupees cost upon you. Yes. What is wrong with you? You take up a brief out there, you don't know you cannot serve it. Where does this respondent reside? It's a stone throw from here. Birubari, Polton Bazar, not even Birubari, Polton Bazar. You take it up on Friday, effect the dusty service by then. You, by yourself. It is seen that the respondent herein resides at Polton Bazar, but the petitioner, for reason best known, have not effected service by way of dusty in spite of due opportunity being given by this court on 23/5/2025. Under such circumstances, this court fixes this matter again on 27th of June 2025. It is observed that if no dusty service is effected upon the respondent by way affected, this court would not be inclined to further extend the interim order. The interim order passed earlier shall continue till the next date.
His justice submission was effected at his home, Gwalpara. And the usual service as well as steps been taken, but reportation has come.
Received.
Yes.
The service, it appears that the service have been duly effected by way of dusty, as would appear from the affidavit in opposition, affidavit of service so filed on 19th of June 2025. Accordingly, however, none has appeared on behalf of the respondent on call. For the ends of justice, the matter stands adjourned to be listed again on 21st of July 2025. List the matter, interim order passed earlier shall continue till the next date. It is observed that if the respondent is not represented on the next date, this court shall be constrained to proceed and pass appropriate orders as deemed fit.
The service report, yet to file affidavit.
Huh?
We need time to file the affidavit. We have received the service report of dusty.
Have you filed it?
No, my lord, we need time to.
You have not filed it.
No.
Why you are not being able to effect service?
We have received it yesterday, service.
Oh. You have not served, you have not given the first steps for usual process? No. So, vacate the interim order. It is seen that the service by way of usual process as directed by this court have not been taken, as it appears from the office note dated 26/2025. Further to that, service by way of dusty have also not been, affidavit of service as well as by dusty have not also been taken, filed. It is seen that this court had issued notice as far back as on 12/3/2025, that is 3 months back, but the petitioner, for best reasons, have not been able to effect service upon the respondents. The said actions on the part of the petitioner does not inspire this court to extend the interim order. This matter again on 16th of July 2025. The interim order passed earlier stands vacated.
matter we have served.
Hmm?
And find the affidavit also. It's not on record book. We filed this morning, so it's not on record.
Where is the RC Paul's name has been shown in the cause list?
We had a word with him. He was possibly in another court, not in the high.
What is the matter about?
So this is a case where my husband had died.
Ah.
We say because of a head-on collision, the insurance people, they take a stand that no, we had dashed some vehicle and hit the truck. While the police is with us, they say it's a charge sheet there. Now this difference of views between the police and the insurance people, the learned tribunal prevailed over the view of the tribunal of insurance and directed for given as compensation by the insurer of our vehicle. We say no, it should be by the insurer of the other vehicle. That's the case. Wagoner and truck. In fact, there are three or four more cases there of the same accident. Different appeals have been filed. In one proceeding on this lines, the lawyer tribunal said that no, your negligence, nothing doing, you not get some compensation given by the wrong insurer.
You have effected service by
Yes,
the
yes,
state?
we
You
filed this
saying that
morning.
the service upon the respond number 1 has been duly effected by way of the state. Pusto. None has appeared on behalf of the respondent number 2 when the matter is solved. Be that it may, taking into account that the LCR has been received, list the matter for hearing in the usual course, liberty given to both parties to file application for early hearing.
Right. Wait.
Service not complete against respond number 2 to 6. None appears on behalf of the appellant on call. Service also is not effected upon respond number 2 to 6. List the appeal for hearing after completion of the service.
Well, Lordship. I have filed one IML for the
Respond number 4 and 6.
Five dots. Service is not as per office note dated 18.
4 and 6. 4 and 5 or 4 and 6? So,
Owner driver, 4 and 5.
okay, respondent service upon the respond number 4 and 5 is not complete. Full stop. You take fresh steps. Mr. Goswami,
Yes, sir, I'll request.
take fresh steps. Taking into account who is 4 and 5? Why do you need 4 and 5?
Yes, against the owner and driver in the sense, the vehicle was being given without a registration certificate, without a valid registration certificate and also fitness.
The appellant is directed to effect service upon respondent number 4 and 5 by way of registered as well as usual within 3 days. This is the matter of the
And, for, deposit of state, the amounts against state, isn't state without deposit. He has filed an application for depositing that amount and also withdrawal. I had also filed an objection, but that objection is not on record. I had filed the objection on, this is the date.
There's a stay granted by this court.
Lordship.
Huh?
It has been
It was
granted
granted without deposit.
without the deposition of the statutory amount.
I filed an objection on 31/7/2023, Lordship, but that's not on record now.
IS things disposed of. What can I do?
That IML is regarding the mostly stay. But this
Stay has
IML
been
the-
disposed of. Then how do I do anything? Can
can
I,
do, my lord.
wouldn't this be a review?
810 of
960. 960, since the connected appeal is admitted for hearing, the operation is disposed of, shall remain state till disposal of the appeal. IAC stands disposed of. I can't help you.
The other IML, the 810 of the 23, my lord, I have filed for depositing the malad.
How can I do it? Wouldn't it be contrary to this order?
Because my lord, as per the provision, my lord, while the admitting the appeal, my lord, the statutory amount.
Where is the provision?
But there's a 173 appeal, my lord.
Ah,
Provided that no appeal by a person who is required to pay an amount in terms of the such award shall be entertained by the High Court unless he has deposited with it 25,000 rupees or 50% of the amount so awarded.
so he has deposited 25%, 25,000. 25,000 he has to deposit. Without that, he cannot maintain the appeal.
That amount he has not deposited.
That he has deposited. Without that, the appeal would not be taken.
That has not been deposited. That's why, my lord, I have filed the I.
Mr. Goswami, are you saying that no statutory deposit? This cannot happen. Yeah, it is given.
Given. Yes.
It's there, 25,000 given. Yeah. You should know what you are saying before a court.
Then, my
This is
lord, I
not
may be
your-
allowed to, my lord,
Mr.
withdraw that, my lord.
Mr. Counsel, this is not your corridors out here to say anything. Say something more responsible. এখন লিখিব হা I-con 810. Mr. So-and-so, the learned counsel appearing on behalf of the applicant submits that taking into account that the appellant have deposited the amount of rupees 25 statutory deposit, he would not like to press the instant application. He, however, submitted that as there is a complete stay, that too without hearing this court or hearing the claimants, this court may take up the appeal for disposal expeditiously. Full stop. Taking into account the above, the instant application stands closed, the registry is directed to list the appeal for hearing immediately upon service being effected upon the respond number 4 and 5. LCL will come.
Sorry. Problem.
Yeah, it will have. LCL. 13 LCL has been received, service not yet complete against sole respondent.
No,
You
no, no, I am the legal aid counsel. I've been.
are appearing. Okay. Okay, service being complete and LCR having been received, list the matter for hearing in the usual course, liberty given to both parties to file application for a new.
Problem.
Yes, what is this? Dismiss for default.
Dismiss for default. In fact, my lord. Say, my lord, I was in another court, and after dismissal, I immediately come before this court, and my learned brother also present on that day, my lord. But
I contact.
court said to file an application, my lord, therefore I file an application.
It has been submitted. This is an application filed under Order 41, Rule 19 of the Code of Civil Procedure 1908 for restoration of the connected RSA number 51/2014, which was dismissed for non-prosecution on 8/8/2024. Full stop. It has been submitted by the learned counsel appearing on behalf of the appellant that on account of he being busy in another court, he could not appear when the matter was called out for hearing. Full stop. He therefore submitted that the client should not suffer on account of the fault of the counsel, and accordingly, the appeal be readmitted. Full stop. The respondent, who is represented by Mr. N. Chaudhary, however, does not object to the same, on the ground that the counsel had, after the order being passed, had appeared before the court. Full stop. Taking into account the above, this court, for the ends of justice, allows the instant application, thereby readmits the appeal, being RSA number 51/2014, and restores the said appeal back to the file. Full stop. I stands closed, the RSA number so and so. Are you appeal? Are you? Concurrent? The law to declare the title on the basis of admitted exhibited documents. What is the admitted exhibited documents?
Exhibited documents, my lord, the gift deed, my lord. Gift deed was not accepted by the Honorable First Appellate Court, my lord. It is basically, my lord, dispute between the sister-in-laws, my lord.
What are the documents, exhibited documents which you are referring to?
Gift deed, my lord,
You are the plaintiff.
I'm the defendant. I'm the defendant, their suit has been dismissed. On appeal, it was reversed, my lord.
Okay, so they submitted the gift deed.
It submitted the-
Defendant did not submit any document. Yes. Kindly see page 26 of the memo paper. Huh? What did you exhibit? Record say? What documents did you submit?
Copy of government
This has been given by the plaintiff.
number.
Hereby begs the following documents in the above noted suit. Jamabandi, one certified copy, Jamabandi for the year 1930-31. That is certified copy. That DW1 did not submit any document. Odoko. Yes. These are certified copy. certified copy.
certified copy.
Okay, now read it. What is protocol? Protocol call so and so জমাবন্দী সত্য প্ৰতিলিপি so and so. মই মাৰ চহী চিনি পাওঁ পদক পৰা 1 নম্বৰ পৰা 5 নম্বৰ লৈ মাৰ চহী. How can they be assigned in a certified copy? Gift given by whom? To
the daughter.
to you. How? Oral. Muslim. Hindu. How?
By protocol for my lord. By protocol for is the gift deed, my lord.
What is this? Protocol is what?
It's a gift deed, my lord.
No protocol. You have not given this protocol. There is no protocol in the year.
But lordship, the protocol for is the 88 number.
No, that document is not here. What? No protocol. How does the learned trial court say? Trial court categorically says that there is no evidence.
Trial court says no evidence regarding the plaintiff, my lord. Regarding the plaintiff, I am the defendant, my lord.
Upon the claim and counterclaim of both the parties, so and so, the claim of the plaintiff is based on facts that there was a right of Iman. When the suit is not barred here, plaintiff has preferred the suit against the persons who have been directed, therefore not here. The plaintiff number 1 on being prosecuted in the capacity that the house was built by her mother-in-law and not by her husband, as stated. The admission itself shows that there is variance in the facts on Iman. Moreover, Iman also stated that she is not aware if the suit house was gifted by her mother-in-law to the defendant. She also, the plaintiff, had put reliance on Exhibit 2, the copy of the Jawabandi to so and so. In all these events, the plaintiff has failed to show that any objection in the appropriate Iman has filed by them. Also, it is also an admitted feeling they are seriously in possession of some tenant and during the hearing, the plaintiff against the law. So, does the first appellate court look into it?
Discuss regarding the partition of the scheduled property, my lord. And where
Trial court categorically says that you have not adduced any evidence. There is no gift deed, nothing. Nothing, nobody's case out there. There is no transfer. There is no gift deed. Hello, we receipt again, 2 o'clock. Mr. Chaudhary, is there any gift deed?
But I have a copy, but not very legible.
No. See from the documents, if you see the plaintiff document, there's nothing out there. The file C1, there's no gift deed. There's only one Jamabandi.
Jawabandi was filed by the plaintiff.
You have filed the Jamabandi.
We filed for and for.
What is core?
This is the part of the matter. And for is the gift deed.
There's no gift deed out here.
Have to check whether it has-
You check it during the lunch. Well, we dispose it.
My evidence manager shown that for and for
in my evidence, my lord, but it was shown as co and co, but I could not find in the plea, my lord. Anyways, my lord, but the truth regarding my lord partition, my lord. Partition among my lord sisters-in-law. My mother was the owner, original owner.
There is no denial of the fact that what was that name? Your father's name?
Con was the original owner.
What
Con
was that
Coach.
name? Father's
Con-
name?
Con Coach.
On course is the owner. Okay. He left behind
With
his wife,
wife, son, and daughter.
his son and daughter.
Son, daughter, and wife.
Daughter. Now,
Now, from the son, my lord.
son died.
Son died.
Son
And,
died, but son died. Son predeceased the wife, mother.
Lordship. Lordship.
Son predeceased
Is
the
the
mother.
So,
So
what,
there is no denial of the fact that Concourse was the owner of around 3 bighas of land.
because
There's no quarrel with that proposition. Now, when he left behind, son got a share. There's no quarrel with that also.
son
Has
died,
to
my
get
lord.
a share.
Son died prior to the mother, my lord.
No, son did not die prior to the father. Son died prior to the mother, not
Mother.
the father.
Yes.
So the son has to get a share.
Yes.
Okay. Now, son gets the share and son marries the plaintiff.
Plenty.
And their daughter is the plaintiff number 2. Is it? Okay. Now, therefore, upon the son's death, this devolved upon the wife, that is the plaintiff number 1 and plaintiff number 2.
Yes.
No quarrel.
But here is some, my lord, a factual dispute, my lord. Because during the lifetime of mother, my lord, after the father might died, my lord, the mother purchased another plot in his name, my lord, in son name. There is a quarrel between the mother and the daughter, my lord. There,
Whatever may be, the father died in the state.
yes,
So therefore, the son has to get a right.
right, right.
Son has a right over that land. There's no quarrel with that.
Well, my pleading was that, my lord.
Now you say that the mother gifted 2 kathas of land to the so and so. Okay. That gift deed is not nowhere to be seen. Okay. Anyways, whatever may be, she gets a share in respect to that gift deed having not been proved. Mother having died after the son having died. In terms with section 15 of the Hindu Succession Act, mother's right will also devolve upon the daughter of the predeceased son, as well as the wife of the predeceased son. And similarly, it will go to the defendant also, mother's share. What is wrong with that judgment of the first appellate court?
My lord, the first appellate court, my lord, on the basis of the pleadings, my lord, which was the entire dispute regarding one RCC building, my lord. The pleading is the defendant is that RCC building was constructed by the defendant and her husband, my lord. That facts, my lord, has not been accepted by the appellate court, whereas the trial court had accepted and, my lord, dismissed the suit on this ground. But on that particular RCC building, my lord, that was not, my lord, explained by the appellate court, my lord. Whereas, my lord, I would like to draw your lordship attention to the plaint, my lord, first. Plaint. Plaint, my lord, they have asked for partition. Partition and the schedule number A, my lord. Schedule A, page 12, my lord, in my appeal memo.
Yes.
The land measuring 1 kata 15 lakhs. They're asking for declaration and right title interest about this portion of land. And whereas, my lord, in the appeal, my lord, final appeal, the order was passed regarding 1 bigha 2 kata 14 lakhs of land. Schedule A and B, my lord. Schedule A and B, their pair is regarding Schedule A.
Schedule A is how much?
1 kata 15 lectures.
Mr. Slater, read it properly. Land measuring 1 katha 15 lectures covered by Dag number 304. 4 kathas covered by Dag number 305. Total 1 biga 15 lectures. We are not reading it properly.
And the schedule B, my lord, 2 kata 15 lectures.
Then, read me. Nothing wrong. Good judgment.
They have admitted, my lord, building was not constructed by them, my lord. They
Who?
built it- my
What
lord,
proof did you give?
Plaintiff, my lord. Plaintiff state, my lord.
Oh, defendant, what proof did you give? That the building was constructed by you.
My lord, my oral.
The court did not come to a finding that the building has been constructed by you.
We have the tenants, my lord. They have admitted that we have the tenants. For last 10, 15 years, we have the tenants about this RCC building, my lord.
You may have tenants, so what? But did you prove that you constructed it? This is a partition suit.
Regarding construction, my lord, we have, through my oral evidence, my lord, we have proved that, my lord.
Oral evidence what? There's nothing, no proof to that effect that you have constructed this way, yeah? You say that the mother constructed it.
Mother constructed with the help of my husband also, my.
Your husband must have paid the money.
Yes, ma'am.
Where is that? Let us see the cross. How does it come?
Cross part, my lord.
Cross of yours. I filed evidence of that. There are 3 pattas of land, Moza so and so. There is approximately Iman. There are some 3 Dag numbers so and so. My uncle Manik Soike and so are here. I have 2 brothers, Tilok and Rana, Rina and my sister who died at the age of Iman. Rana died who was Iman. My father died in the year 90. At the time, all the 4 children were alive. Rina died 6 months after my father died. Rana died after 2 months of Rina's death. My mother died in 99. Tilok died in 1985. Tilok married 50 and had a son. Alive, Tilok married 1982 and he died in the rented house at Amalapati, Nagaon. He was a government employee working in irrigation. I joined the school in Toronto. There is a Assam-type house. There is another RCC house on the Sudan Mainland. I was married to a family of Botu. Once I got the job, I came back to Nagaon. In 1999, my brother used to reside at Amalapati in Pakistan. The name of my deceased Tilak there in the Namduri. After Tilak's death, his wife, so and so got entered in the Namdari record, and there is no imperfect partition between the revenue authority in RCC building. I have given on when I collect when I constructed the year during 94 to 96. I have obtained permission from the authorities before making the construction, and I have filed those documents with the Plaint. I spent about 3 lakh rupees to construct that building. My husband was a contractor and he helped me financially to build the building. Our house falls outside the municipal area. There is no holding number. The RCC building is on 1 katha of land. Earlier part of the building was constructed by some mystery whose name I do not know. Moinul did the job of plastering in the Iman. My mother gave a gift of 2 kathas of land approximately. I have filed the gift deed. I performed the Shraddha of my mother. I have not filed any case to cancel the Namjari of Tripti. I have sold 2 kathas of land to Vipul Das and others by registered sale deed from the Iman. The 2 kathas of land is behind the Assam type house. My mother did not have good relation with Tilak. I also did not. I have not filed any document to show that I have spent 3 lakhs for the construction of the Iman. I have not obtained permission to construct RCC building as that was not the permission was required. It is not a fact that the RCC was constructed by Tilak. It is not a fact that the 1,000 point of the suit land belongs to Tilak. It is not a fact that so and so belongs to 50. It is not a fact that it is not a fact that so and so on the eastern side of TP number there is a Pukuri in the land of so and so. On the northern side we have land and so and so. Now openly listen to my so and so. Of land to fill up. It is not a so what is wrong?
during the lifetime, they have their pleading is that during the lifetime of the tilak and the mother, my lord, they have got a partition of the scheduled property. Amicably.
That you have not proved it.
That was not proved, my lord. That was not proved, and they said, my lord, the person who is the building lies, my lord, in their possession, my lord. Whereas the
So the
building,
court fixes it that she is entitled to this amount of land, that's all. And directs that partition be carried out. What is wrong with that?
that part, my lord,
That is the direction passed by the first appellate court.
partition part, my lord, half portion of it.
There is no admitted evidence out here. What admitted evidence you are referring to? There is no admitted evidence.
They are cross also. They have submitted the building was constructed by my mother and the defendants, my lord, in their cross, my lord.
Let us assume that you have constructed so. She has a share into that land.
They-
Merely because you have constructed a building, would your land become yours?
Because in this case, my lord, particular case, the land which, my lord, we are possessing now, my lord, my mother has already purchased another plot of land in favor of the son, the husband of the plaintiff, my lord. That was admitted position, my lord. We are not claiming on that position, portion of land. And it is a pleaded case, my lord, that they have relinquished because there was no cordial relation between mother and son. my
How
lord.
could they relinquish if there is no cordial relationship? Tell me. Let us be more enlightened. Somebody will willingly relinquish because I don't like you, my mother. Tell me.
It's a pleaded case, my lord, because they have said, my lord, my mother has purchased another plot of land at Amulapatti, my lord. And they have staying separately for last 35 years. And suddenly after death of the son, my lord, the present plaintiff is for file this present suit, my lord, for partition.
Similarly, the name, the Namjari containing the name of your of the brother, of your brother,
Brother died long back.
not your father, your brother, who died in 1985.
Yes.
His name was also included in the Namjari.
Yes.
Then you did not take any steps for removing the name. What is wrong with the judgment? Rightly passed. Substantial question of law does not arise. Yes. What do you have to say?
One of the relief otherwise was granted with the stated, the share as was stated by us, the share has been rightfully decided by the appellate court. A calculation has been very well shown by the appellate court properly as to what share is each of the parties is entitled to. Initially, there were 4 legal heirs of concourse, but at present there are only 3. I'm sorry, 4. 4, that is the son and daughter of Meena Soikia, defendant number 1, and the son, wife and son of Tilak Soikia. So Tilak Soikia and Meena Soikia are entitled to the share of the property. That has been very well decided by the appellate court.
Well, discussing the, my lord, issue, main issue, my lord, to page 38, my lord, paragraph 18. The appellate court judgment, my lord, paragraph 18. PW plaintiff in her evidence deposed that claim originally belonged to her father-in-law, Concourse. She stated her mother-in-law, Renu Soikia, died in 1999 and her husband died in 1985. She stated her mother-in-law purchased the land at Amulapatti where she is now staying. And her mother-in-law worked in the civil hospital and she was no knowledge how the suit was occupied and possessed by her in-law family prior to her marriage. And from the year 1987, she permanently settled at Amulapatti. She stated Assam type house was constructed prior to her marriage. She
don't know who had constructed the same, and subsequently her mother-in-law constructed one RCC house over the suit land, and construction was completed prior to her death. And of her mother-in-law, and how now the RCC house was let out to tenant by defendant for last 10 years.
So, unless you prove there was a gift deed by the mother of that RCC building to you,
So in fact, my lord, in my evidence part, my lord, which I have possessed, my lord.
no,
that
no,
shows-
no. You have said about 2 kathas of land was gifted to you. You have sold that to some Dilip Soikia or somebody. Then okay. Appeal should have been allowed with cost. That allowed by the first appellate court. So we'll incorporate that 11,000 plus here the current rate of 22,033. Appeal dismissed with cost of 33. Chalo. Heard Mr. S. Dr. Siladitya, the learned counsel appearing on behalf of the appellant, Mr. N. Chaudhary, who appears on behalf of the respondent. The instant appeal has been filed challenging the judgment and decree dated 9th of October 2013, passed by the learned court of the civil judge in Nagaon, hereinafter referred to as the learned first appellate court, thereby interfering with the judgment and decree of the learned learned court of the Munsif number 1 Nagaon, dated 23/3/2012, may passed in title suit number 69/2005, Munsif Court of the Learned Trial Court. Whereby the suit filed by the plaintiff was decreed. Pusto.
Suit was dismissed, dismissed. Suit was dismissed.
Interfered? No, the suit was filed by the plaintiff was decreed. Suit was dismissed by the trial court. That has been interfered with, and the first appellate court decreed it. Then
Yes.
it's seen from the records that the learned that the learned coordinate bench of this court by an order dated 14/2/2014 admitted the instant appeal by formulating two substantial questions of law, which reads as under. Next, the question arises as to whether the two substantial questions of law are involved in the instant appeal. This court, in this regard, have duly heard Mr. Siladitya, the learned counsel, appearing on behalf of the appellant, as well as Mr. N. Chaudhary, the learned counsel, appearing on behalf of the respondent. For ascertaining as to whether the two substantial questions of law so formulated are involved in the instant appeal, this court finds it relevant to take note of the brief facts which led to the filing of the instant appeal. For the sake of convenience, the parties herein are referred to in the same status they were before the learned trial court. From the materials on record, it is seen from the admitted facts amongst the parties, it is apparent that Pawn Coach was the owner of a plot of land at measuring three biga, 2 katha, 8/2 lecha in patta number 88, covered by dark numbers 304, 305, and 308. That's admitted. Three zero four and 305 and 308 also, na?
Yes,
Ah,
my lord,
okay.
see that.
Video. Pusto. The said concoach expired in the year 19.
85.
Huh?
Phone coach, my lord, is. Was not given even kilo point other than 85.
19, somewhere it is there, na? And this evidence it is occurring. No? In the year 1962, leaving behind his wife, Renu Soikia, his son, Tilok Soikia, and the defendant, Minu Soikia. Minu na?
Mina. Mina Sekir.
Mina Soikia.
My lord, there was another son who died unmarried.
They died, yeah. Leaving behind so and so. Leaving behind his wife, Renu Soikia, 2 sons, Rana Soikia and Tilok Soikia, and 2 daughters, Rina Soikia and the defendant Mina Soikia. Pusto. The admitted facts further show that Rina Soikia and Rana Soikia expired immediately after the death of Konkuch, at a tender age, leaving behind no heirs. Pusto. Tilok Soikia married the plaintiff number 1 in the year 1981, and out of their wedlock, plaintiff number 2 was born. Pusto. Thereupon, Tilok Soikia expired in the year 1985. Pusto. From the above facts, it is therefore clear that the land which late Konkoch inherited devolved upon his wife, late Renu Soikia, his son, late Tilak Soikia, and his daughter, that the defendant number one. The defendant, no?
Yes, yes.
Defendant.
Defendant number one,
Defendant number one.
who is her husband.
After the death of Tilak Soikia, his share devolved upon the plaintiff number one and plaintiff number two. Full stop. It is further relevant to take note of that the mother-in-law of the plaintiff number one expired in the year 1999, isn't it?
Yes, ma'am.
And therefore, by virtue of Section 15 of the Hindu Succession Act 1956, her right in respect to her share devolved upon the defendant number one and in one part, and the plaintiff number one and two in the other. Accordingly, the plaintiff, being deprived of her rights, claiming being deprived of her rights in respect to the suit property as described in the schedule to the plaint, had filed a suit being titled suit number 69/2005, seeking declaration of her right, title, and interest in respect to the suit land, more specifically described in Schedule A to the plaint, for a preliminary decree for partition, a decree for delivery of khas possession of the suit land along with the Assam type house standing thereon, by ejecting the defendant with their tenants and put the plaintiff into possession, a precept be issued to the Revenue Department for partition of the plaintiff's share over the suit land and for permanent injunction. The defendant number one and two, who is the daughter of Konkoch, late Konkoch, and a husband,
Anil, yes,
Huh?
husband,
husband,
and her husband.
jointly filed a written statement claiming right over the entire suit land on the ground that late Tilak Soikia, having no cordial relationship with the mother, left his parental house about 35 years back and settled at Amlapati, Nagaon. And their mother, Renu Soikia, who worked in the health department, purchased a plot of land at Amlapati and constructed a house thereon and gave the said property to Tilak Soikia. And their mother, Renu Soikia, during her lifetime made it clear that Tilak Soikia will not claim any share over the suit patta land and the RCC building standing on the suit land constructed by her and her husband and the assigned type house was constructed by her mother, Renu Saikia, and therefore the plaintiff had no claim over the land in the suit patta. It was further pleaded that Renu Saikia gifted 2 kathas of land from the suit dag number 308, PP number 88, with the standing houses by a registered gift deed number 4323/91, dated 22/11/91. Full stop. On the basis of the pleadings, the learned trial court framed as many as 7 issues. Full stop. On behalf of the plaintiff, there were 2 witnesses, na? The 3 witnesses were examined and 8 documents were exhibited. On behalf of the defendant, only 1 witness was examined, but no documents were exhibited. Full stop. The learned trial court decided the issue number 1 to 4 in favor of the plaintiff, but decided the issue number 5 and 6 against the plaintiff, and accordingly dismissed the suit. It is very pertinent to take note of the observations made by the learned trial court while deciding the issue number 5, which relates whereby it was held that the plaintiff could not prove right to claim any share in the suit land. The reasons were assigned therein was that as the defendants were in possession over the suit land, the plaintiff number 1 had no right to claim any share in the said suit land. Being agreed, the plaintiff preferred an appeal which was registered and numbered as title appeal number 15/2012. The learned trial court, First Appellate Court, after taking into account the grounds of objection, the submissions so made by both the parties, the pleaded cases of the parties, the submissions so made by the parties, and after framing the points for determination, decided that interfered with the judgment and decree passed by the learned First Appellate Court, the trial court, and held that the plaintiff was entitled for share in the suit dag and patta of 1 katha, 1 biga, 1 katha, 14.893 lecha out of total 3 biga, 2 katha, 8 by 2/3 lecha covered by drag number 304, 305, 308 of PP number 88. Accordingly, the learned trial court, First Appellate Court, decreed the suit in favor of the plaintiffs, and a precept was directed to be issued by the learned trial court for partition of the suit land, and possession of the plaintiff's share over the land would be delivered after partition and separate patta. Being aggrieved, the present appeal has been preferred. In the backdrop of the above, let this court now consider the two substantial questions of law which have been formulated as to whether they are involved. The first substantial question of law pertains to as to whether the learned lower appellate court erred in law to declare the title of the plaintiff on the basis of admitted exhibited documents. Full stop. This court had perused the judgment passed by the learned First Appellate Court, and more particularly the discussion on the basis of the evidence so adduced. From a perusal of the said, it appears to this court that there is no perversity on the findings so arrived at by the learned First Appellate Court. On the findings of facts so arrived at by the learned First Appellate Court. First, considering that there is no perversity, the substantial question of law so formulated, the first substantial question of law so formulated does not arise in the instant appeal, is not involved in the instant appeal. First, next. The second substantial question of law pertains to as to whether the learned lower appellate court erred in law in reversing the finding of the learned without considering the reasons basing on which the learned trial court's decree was passed. First, in the opinion of this court, with due respect, the said cannot under any circumstances be said to be a substantial question of law which can be formulated in a second appeal. First, be that as it may, this court have duly perused the discussions so made by the learned trial court, whereby the plaintiff's right over the suit land have been discarded merely on the basis that the defendants were in possession of the suit land. It is a well-settled principle of law that the possession of a co-owner is always regarded as a possession of all the co-owners. Under such circumstances, the reasons so assigned by the learned trial court while deciding the issue number 5 was completely erroneous. On the other hand, the judgment so passed by the learned First Appellate Court duly discusses the evidence on record and have arrived at the finding of fact, which under no circumstances can be said to be perverse. First, considering the above, this court is of the opinion that the two substantial questions of law so formulated are not involved in the instant appeal. First, this court further finds it relevant to observe that there is no other further substantial question of law which arises in the instant appeal. First, accordingly, the appeal is devoid of any merits for which the same stands dismissed. First, taking into account the materials on record, taking into account the above, this court imposes a cost of rupees 22,000 upon the appellants. First, in addition to that, the appellant shall be entitled to costs throughout the proceedings. Ah,
Maybe.
okay, 11. I didn't know. 245 উঠিম। এইকেইটা শেষ করো অর্ডার কেইটা আৰু কোনকেইটা আছে? অর্ডার কেইটা শেষ করো।
File my affidavit, some record, my lord.
Hello, we'll take it after vacation. It has been submitted by so and so, the learned counsel, Deposit Goswami. The learned counsel appearing on behalf of the respondent that an affidavit has been filed, who lists this matter on 6th of August 2025.
Response number 8, notice services adequate.
Required
Required.
service upon respond number 8 being not complete, comma, the appellant is directed to take fresh steps upon the respondent number 8 within 3 days by registered as well as usual.
Problem.
Why are so many people in this party?
My lord, in the title suit, my lord, there are parties, we made parties to them, my lord.
Title suit.
Yes, my lord.
Why you are asking for the transfer?
My lord, the petitioner, both petitioners are old and aged person, my lord. One is 66 years old and one is 65 years old, my lord. My lord, they are from Lakhimpur, and for that, they have to go to the, Tinsukia, my lord. So, for medical grounds only, we are asking for transfer.
Why?
But for medical grounds, my lord.
You don't have to go, we send the lawyer will appear.
My lord,
This is a title suit, not a matrimonial suit.
yes, my lord, my lord.
Then
Title suit in, title suit. Well, it is a title suit FA, my lord, Fatal Accident Act, under Fatal Accident Act, my lord. My lord, the son of the petitioner died in an accident in, Tinsukia, my lord. So, and petitioner filed this title suit for compensation of 50 lakhs.
okay, service upon Dusty affidavit regarding service has not been filed.
My lord, I may be granted one more opportunity to file the Dusty, my lord.
The counsel appearing on behalf of the appellant petitioner submits that one more chance may be granted to them, to the petitioner for filing the affidavit by way of Dusty. This matter on 13th of August 2025. In the meantime, the petitioner shall effect service by the way of Dusty upon the respond number 427 and file an affidavit of service, full stop, on or before the next date, comma. The interim order passed earlier shall continue till then.
There is no,
Okay, no
my
interim.
lord, my lord. With respect of respondent number 4 and 7, my lord, this was served, my lord, and service is completed, my lord. Only 5 is left.
I'm appearing for respondent number 6. I have not got the complete copy. I've only got the petition copy. This is what was been submitted to me, without the annexes and anything.
Ask him. Good friend of yours. Ask him.
My lord, if the direction is there, it will be useful, my lord.
I don't want to enter into the disputed territory amongst other side. I think both of you should fight it out on that, outside the
I'm
court.
appearing for respondents 1 and 3.
So service is not complete against whom? 4.
No, 5, my lord. 5.
4?
4 completed, my lord.
Okay, upon 5 বুলি কৈ দিব। 5. খালি 5 বলে interim order নাই।
Not super.
It's complete, my.
Service complete. Okay. What is this FAO business?
We are challenging the order of grant of receiver, my. Receiver, appointment of a receiver, my.
Receiver.
Receiver of rent, my.
Oh, you're challenging it.
My lord. Partition, sir.
Okay. We'll have it immediately after vacation.
Yes, my lord. Only hearing them.
Not necessary. Okay, 23rd of July. Not hearing date. With the service being complete, list this matter on 23rd of July 2025. Full stop. on which date an attempt shall be made to dispose of the appeal.
Okay.
Transfer from where to where?
From Principal Judge Guwahati to Nagaon, my lords.
Lordship, we have filed the affidavit in opposition, your Lordship.
She working?
No, my lord.
She's a doctor, your Lordship. She's a
not working, my
physiotherapist.
Doctor?
Yes, your Lordship.
My lord, she's not working. And there are other grounds also, my lord.
What other grounds?
That her mother is also sick, and there's another two cases that has been filed in the pendency of this case at Guwahati. And for those also, he has to travel to Nagaon, my lord.
Huh?
There are other two cases that has been filed in the meantime, my lord.
Other two cases also give
Yes,
it,
my lord.
we put it out there at Nagaon. No, where are those cases filed?
They have filed something.
Yes, sir.
We haven't received any notice till now.
Your case is here.
Yeah, Lordship.
Yes, sir.
Okay, well, you give the details, we transfer those cases to Guwahati.
I did that, my lord. I did, my lord.
I have received
My lord has
information that
asked
they have
me
filed
to-
DV case which cannot be taken up before the same court, your Lordship. And besides.
Doctor,
Yes, your Lordship.
No, my lord.
MBBS?
She's not- My lord, she
Is she MBBS?
took it to work while she was married to the person.
Now you are free.
She's a physiotherapist.
MBBS? Physiotherapist?
Completed a master's here. That is still pending. That was a.
You are studying?
The facts of the case. narration.
Now, are you studying?
No, my lord, we were studying at 10 earlier. But at the time when.
No, now? Then how will you complete masters if you are not studying?
Somewhere near to Tezpur, my lord. She's looking out for options. There are masters.
Why do you study? Study out here in Guwahati. Come here every day.
And Lordship, she is coming to Guwahati for treatment. The mother, he says,
mother
my
is
learned
coming,
friend
my
is saying that she is ill. She is coming to Guwahati for treatment. All the
My lord-
medical documents are for
Ah,
from
my lord,
Guwahati on the same date, your
My
Lord.
lord, Nogo also
okay.
treatment is
This
going
item
on.
number, Iman, on which date? We'll find it out on, there's no stay.
Tuesday, my lord.
What is the next date?
19th of July.
19th of July, na? We'll finish it off on 16th.
Lordship, can it be made on 17th or 18th?
Absolutely no. 16th is 16th.
Much of that.
Service not complete.
And LCR also not received.
Service not complete leaves the appeal after completion of service.
Lordship, there is stay.
What stay?
Pay for.
No stay, no stay. Service, if you have not been able to complete, no stay. Pay money.
Application for substitution.
Aero date eta fix korbi. Replace stay to extend till then.
Lordship, in compliance to Lordship's orders,
Service complete.
service is complete, Lordship.
Service complete. What is
I
this
can-
IA business?
For substitution of respondent number 2.
Done.
Yes, sir.
Service
That
complete.
is the application filed by them. We informed that about the death of the respondent number 2. They have filed
Service
this-
is complete. It will like on substitution
Yes,
within time.
yes, because we have informed and Lord, they have filed within time.
Okay. Ekon substitution kon allow kori dibo. Substituted so and so, so and so, so and so. Huh? As appellant number, respondent number 2.1, 2.2 and 2.3. After econon, RSA econon. You are appealing for these two
All,
conon,
all.
so and so accepts notice, so that accordingly service is complete. List them appeal for hearing in the usual course, liberty given
But
to
can
both
it be?
liberty
No,
given to
that's
both
not-
the parties for filing application for early hearing.
22, 23 not connected.
32, no dusty service. 14 days, no, you have not affected service by dusty. You have filed it. Chalo, service being complete. You are appearing. Okay, how much is the delay? Oh, condone? Don't oppose?
So as per my knowledge is concerned, no provision for second appeal is there, madam.
Don't worry. First, let me do it. Do it and then let me dismiss his petition, Bishop, later on. Yes. I'll record your submission. Then also, if he continues, then in that case, he would not get the benefit of the delay. You take that risk, no? This is an application filed under Section 5 of the Limitation Act, read with Order 41, Rule 23A of the Code for condoning the delay of how many days? 14 days in preferring the accompanying appeal. Full stop. The learned counsel appears on behalf of the respondent numbers, all the respondents, and submits that the instant appeal is not appeal is not maintainable, taking into account that the suit is in which the decree which is being challenged is in respect to a suit filed under the Assam Urban Area Rent Control Act, whereby there is no appeal permitted. This court, however, this court in that regard had inquired with Mr. J. Roy, the learned senior counsel, as regard the said aspect. He, however, submits that the appeal is maintainable. So taking into account the reasons, however, as assigned, the delay of 14 days is condoned, I stands disposed, registry shall here do register the RSA and list the appeal for consideration under Order 41, Rule 11 on 16th of July 2025. Huh? Chalo, done.
If I may be allowed to appear through VC because I'll be in Delhi on that day.
It always asks for.
Much